Well, hello and welcome to another in the GLG Property Law series. Our aim here is to keep all of those involved in property advised of trending patterns and changes in property law. We hope you enjoy our papers. We welcome you to GLG Legal. If you like what you see here, please hit the like button down below. The first topic I want to deal with is what vehicle should you own when you're buying a property? This is an important question and you should get legal and or accounting advice on that issue. That in itself is a separate topic, and there's a link below to a topic on corporate structures for property. For the moment, I'm going to assume that we're going to use a family trust or a discretionary trust for the acquisition of property. These are the most common. They have benefits in that the ownership is not fixed. If the owner becomes bankrupt, the property is exempt from that bankruptcy because it's in a trust. We can also distribute the capital ownership to the principal, his family members, other family trusts and so forth. So it gives us a great deal of latitude with respect to distributing income and the capital gains, hopefully, at the end of the transaction. There are downsides to discretionary trusts, but for the moment, most people use discretionary trusts for the acquisition of property. Now that was all well and good up until a few years ago when the state government started getting very greedy. The problem started with a lot of foreigners buying property in Australia. Many state governments introduced what they call foreign acquirers duty, which means that a foreigner buying land in Queensland, for example, will pay an extra 7% in stamp duty. The same provisions apply in New South Wales and Victoria. Not content with this, the governments have also introduced a similar regime with respect to land tax, so that foreign owners of land in New South Wales, Victoria and Queensland will pay additional land tax of up to 4%. So how does that involve me, you say? I'm a resident, so what have I got to do with me? I mentioned before that discretionary trusts mean that the property is not owned by the principal. It's not owned by you, it's owned by the trust. And the important issue here is the residence of the trust. Now, the old law of trust was pretty clear on this. The residence of the trust was where the controlling mind resided. However, in their grab for money, the state governments have decided that that's not good enough for them. In New South Wales and Victoria particularly, and in Tasmania, they have now legislated that if property is owned by a discretionary trust, and it is possible for a non-resident to receive any income or capital from that trust, then that will be a non-resident trust for the purpose of land tax and capital gains tax. Now, this wouldn't be such a problem except for the fact that the family trusts have traditionally been drawn in a very wide sense to enable you to distribute income and capital to a very broad class of beneficiaries. Normally those beneficiaries include the principal's spouse, all of the principal's children, all of his grandchildren, his mother, father, brothers, sisters, uncles, aunties, and any children of them, and any company or trust in which any of them have an interest. That is the usual class of beneficiaries. You'll realise that is enormous. And it is quite likely that one of those persons or one of those companies or one of those trusts has a beneficiary that is a non-resident. And if the New South Wales Stamp Duties Office find out about this, or the Victorian Land Tax Office find out about this, your trust will be a non-resident trust. Fortunately, these laws have not yet been adopted in Queensland and they appear less likely now with the recent change of government, but nevertheless one needs to be very careful and pay attention to these issues. We've had clients looking to buy property in New South Wales and Victoria. We've had the discussion about whether it should be in the form of a discretionary trust, and if it is, we usually set up a new purpose-built discretionary trust for the purpose of holding property in these jurisdictions. Where these trusts are different, amongst other things, is that the class of beneficiaries is much more limited. It will usually be the principal, spouse, children, if they're all resident, probably grandchildren, probably will not include trusts and companies that any of those persons might have an interest in, because we don't want to attract the possibility of someone being a non-resident. So if you are going to buy property in other jurisdictions, don't just charge in with your existing family trust and buy it. You're heading for trouble. Come and talk to us first. Let us review the trust deed and tell you whether there is a problem. And if there is, we may be able to amend that trust deed or recommend that you adopt a new trust specifically for that purpose. That, of course, has its own complications. Having a number of different trusts results in isolation of income, losses, capital losses, capital gains and so forth, so is not ideal. But if we have to do it, we need to pay attention to that. So the upshot of this is definitely continue to invest in property and don't rule out investing in other jurisdictions. But if you're looking at using a discretionary trust, which is probably what you'll be recommended to use, pay careful attention to that, particularly that class of beneficiaries and the ability to distribute income. Some of those jurisdictions require an express exclusion of foreign beneficiaries before they'll consider the trust to be a non-resident trust. So please seek our advice on that issue before you proceed with such a purchase. Thank you. Okay, that's that one.
That's amazing.